Have you ever tried to draft your own quitclaim deed or some other kind of deed? As an attorney, I've seen plenty of deeds that were not done properly. So, I'm attorney Vernita Williams. I want to tell you how to draft a deed so that if you're planning to do this, you will have a little bit of guidance and perhaps that deed will do what you intended to do. I have 10 things to tell you. Number one, you need, when you draft the deed, to list the marital status of both the grantor and the grantee. The grantor is the person who's transferring the property, and the grantee is the person who is receiving the property. Now, let me give you a little warning. Please do not list the incorrect marital status. I've known many people to say single because they didn't want their spouse involved in their deeds and their property transactions. Well, if you're married, saying you're single does not mean that you are single. And it creates all kind of suspicion when there's occasion to look at the deed and you didn't give the right marital status. So, number one, give the marital status of both the grantor and the grantee. Number two, make sure you use the correct ownership interest. If you're deeding from yourself to somebody else, is your deed going to create a tenants in common? Will it create a tenancy by the entirety? Will it create a ladybird deed? Are you creating a joint tenant with right of survivorship? Now, if you don't know what I'm talking about, then maybe you shouldn't be doing your own deed. But number two, make sure you create the correct ownership interest. Number three, please, by all means, use the correct legal description. Many times I will see a deed and somebody just went and copied maybe what the tax collector's office listed as a legal description, or they copied what the county property appraiser's office listed. Those are abbreviations that really should not be in a formal deed. So you should use the correct legal description. That's number three. Number four, in your deed, you should indicate who prepared the deed. And number five, you should indicate who to return the deed to. There should be an address and the name of the party to whom the deed should be returned, because normally when you file a deed, your recording office will keep the deed. They'll run it through the microfilm so they can put it in the public records and you can see it digitally, and then they will send you back the original. So number five, tell them who to send the deed to and what is their address. Number six, you should have the address of the grantor, that's the person that's deeding the property, on the deed right underneath the place where they sign. Number seven, you should indicate whether the property is the homestead of the grantor or the grantee. That is extremely important to identify whether a property is homestead. Number eight, please list the witnesses' names clearly, and they should, the witnesses' names should be very clear, and they should see you signing the deed. You should not sign a deed, then go somewhere and say, okay, I've signed it, would you witness it? Well, they didn't witness you signing, and the fact that they did not see you sign your deed could become an issue later on. So make sure your witnesses sign clearly, you know what their names are, and make sure they saw you sign the deed. So if that issue comes up in litigation later on, they can say, yes, I was there, I witnessed, and I literally saw the person who was doing the deed sign the deed. Number nine, make sure your notary is present when you and the witnesses sign. Also, make sure that that notary collects identification from your witnesses. Make sure that notary writes the address and something like the driver's license number for your witnesses, because if that deed ever gets litigated, that notary is going to need to have some kind of ID record on file, and they need to know the name and the address for the person that did the signing as a witness. Number 10, and this is extremely important, if any of these things that I have said before number 10, anything in step number 1, 2, 3, 4, 5, 6, 7, 8, 9, doesn't make any sense to you, then that's probably a good indication that you should not be doing a deed and that you should seek legal counsel. So those are the 10 things that I recommend that you do. They are especially suitable for the state of Florida and for any other state. If you are doing a deed pertaining to individuals, now this is not for if you are doing a deed for a trust or if you are doing a deed for corporations. There are some other things that I would tell you about those. For more information on the proper way to do a deed, you can contact me at 786-831-9483. That's 786-831-9483.